Good evening. We're going to get started. Thank you for coming this evening for the pro bono training on the Deferred Action Program for Childhood Entrance. And my name is Lynn Kelly. I'm the Executive Director at the City Bar Justice Center. And we are so happy to see all of you. And thank you very much for turning out for this important pro bono effort to help children take advantage of this program if they fit the eligibility requirements and it makes sense in their particular circumstance. So you're going to hear from two wonderful trainers this evening. We are very honored to have Maria Navarro, who's a supervising attorney in the immigration unit at the Legal Aid Society. She is currently teaching an immigrant defense externship at Columbia Law School, which she's done for a number of years. She's a graduate of Fordham University and NYU School of Law, and she has over 15 years experience with the Legal Aid Society doing immigration law. I have gotten a chance to work with Maria on a number of different kinds of pro bono projects, and she's a fabulous lawyer, and we're just thrilled that she could be with us tonight. Also this evening, we have Barbara Camacho to my left, who is the Fragaman Fellow at the City Bar Justice Center. Many of you know the Fragaman firm is the largest immigration firm in the world. Barbara is funded to work with the Justice Center for 2 years on access to justice for immigrants, and also runs our detention project. She was formerly with Kind as the Kind attorney in New Jersey working with children. Both attorneys are fluent in Spanish, very experienced in working with immigrant populations in New York. Barbara is a graduate of Seton Hall Law School, just a terrific attorney also. So I think it's a real treat for all of you this evening. Just a few housekeeping details at the bar. Unfortunately, the air conditioning is not working well in this room. Feel free to take your coats off. And there are sodas and ice. Feel free to get up and get yourself a soda or an ice when you need one. The bathrooms are just out this door to the right in the CLE area. There are men's and women's bathrooms. And then just straight back into the reception area across the hall, and to the right there is also a set of bathrooms. So if you need a bathroom, feel free to get up. The training tonight is hopefully going to take 2 hours. It may run into a little bit after 8 o'clock, but it's really set to go until 8 o'clock. So with that, I'm going to turn it over to our trainers, and as I said, feel free to get up and get a drink if you need one, or to use the bathroom. We're going to try and go straight through to get through all the material and then get you out of here. And thank you again for volunteering.
So good evening. As Lynn said, my name is Barbara Camacho, and I'm just going to jump right in. So I'm going to begin by giving you a brief context of where DACA sort of came from. It's an outgrowth of the DREAM Act. It's not the DREAM Act. It's something that came out as a result of frustration in Congress or for the DREAM Act not being passed. So the DREAM Act was a piece of legislation that allowed childhood arrivals who came to the United States and met certain other criteria to be eligible for a pathway to legalization. And it's been in Congress for over a decade, and in each single year, there were some tweaks to what was required, and typically it always included a path to legalization. As I talked about earlier, there was frustration because it wasn't passed, and so the Obama administration decided that prosecutorial discretion would be a tool that would be used in order to give these childhood arrivals an opportunity to have essentially a work permit. So the acronym that has been used by the government is DACA, and that just stands for Deferred Action for Childhood Arrivals, to distinguish it from other programs that the DHS has created under this guise of prosecutorial discretion. There are certain powers that any agency that has the power to enforce laws have, and this is a list of some of the more common powers. So for instance, any agency with the power to enforce will also have the power to determine whether they're going to charge a person, what they're going to charge the person with, whether to drop charges, or whether to administratively close or terminate a case. So DACA is a form of this because it's telling the individual, we know you're here, we know you're undocumented, but we are not going to remove you from the country. So one of the things that DACA does is it allows ICE ICE stands for Immigration Customs Enforcement, to focus its limited resources on priorities that they deem top priorities. So those on your slides include the top 3 priorities, and they are aliens who pose a danger to national security or a risk to public safety. That's going to be people who've been convicted of crimes, recent illegal entrants, and aliens who are fugitives or otherwise obstruct immigration controls. So what is deferred action? Deferred action simply means that an individual who is granted deferred action will not have to face removal. So essentially, it presses pause on their current situation. It's a postponement of any removal action. So if the government isn't aware that you are here, and they suddenly become aware that you are here, they are not going to place you in removal proceedings. If the government is aware that you're here and you're already in immigration removal proceedings, you are not going to be removed. So it is a pause or postponement of removal action. If you're granted deferred action, it will be valid for 2 years, and it is subject to renewal, provided that it hasn't been terminated on another basis. These are the benefits of deferred action we talked about briefly. You're not going to be subject to removal, physical removal from the United States. You're not going to accrue what's called unlawful presence in the United States, and you will be eligible for a work permit. This is not, however, legal status. It is not, however, a pathway to citizenship. It does not allow you to reunite with family, such that if I applied, I could not just attach my sibling or attach my parent or my child. So it isn't going to be something that can be used for family reunification. It doesn't allow the children or young adults who might be eligible to qualify for federal aid either. And because it is a prosecutorial tool, a discretionary tool, it can be terminated at any point. So this administration can do a 180, or the next administration can choose not to continue to have this program available. So there are basically 5 criteria that you need for eligibility that you need to demonstrate, and that's going to turn on age, your date of U.S. entry, your physical presence, your status, and education or your military service. We are also going to talk today about disqualifiers or bars, that is things that can make you ineligible, or things that should be reviewed, because if you are ineligible, you could suffer severe consequences for it. So with respect to the age, there are a couple of things that you should bear in mind. For instance, you must be at least 15 years old and under 31 years old in order for you to apply. That is, as of June 15th of this year, you have not already attained the age of 31. And you have to have arrived in the United States prior to your 16th birthday. There is an exception to the age requirement. So, if you're under the age of 15, and you are currently in removal proceedings are proceedings initiated by the Department of Homeland Security when they have a reason to believe that you are here without permission, or you have overstayed your permission to be in this country, or you have permission but you've run afoul of some immigration law. For instance, you've committed a crime, which makes you now removable. So much like in criminal court, you have a trial. In immigration court, that's called removal proceedings. So if you're 15 or under and you are in removal proceedings, and yes, children are in removal proceedings all the time. My youngest client was 5 years old. You do not have to meet this requirement. So you can be younger than 15 and still apply for DACA. If you have a final order of removal and you're younger than 15, you could still come and apply for DACA. Also, if you have a voluntary order, a voluntary departure order, you can also apply. A voluntary departure order is an order that leaves it in your hands to depart. The government will give you a piece of paper that says you must depart the country within 3 months, and it is up to you to depart and comply with that order. If you fail to do so, that order will automatically become a removal order. If you have a child under those circumstances, that person would still be eligible for DACA. Well, how do you show that the person is within the appropriate age or over the age of 15 at the time of filing, unless they meet one of those discrete categories? These are typical proofs that might be used to show that. So DHS is going to accept a foreign passport, a birth certificate and photo identification, a national identity document from your home country with a photo or a fingerprint. This is important because as volunteer attorneys, when you are going through question by question, you have to make sure that they have one of these pieces of evidence in order to make sure that you check off in your checklist, yes, they have met the age requirement. So these are the kinds of forms that you're going to be looking for when you're reviewing the applicant's evidence. You can also use secondary evidence such as baptismal certificates or affidavit by parents if nothing else is available. Obviously, we prefer that they have one of the top ones. And if the applicant doesn't have a passport or a birth certificate, typically they can contact their consulate and the consulate can help them get a duplicate. You must also show that you entered the country before you turned 16. And so evidence to show that can be a passport with an admission stamp, and we're going to see an example of that later on, or Form I-94, I-95, or I-94. Those are all arrival and departure records, and you're going to see some examples of that in the slides, as well as school records from schools attended. That's probably the best form of evidence, the school records from schools attended, because typically, if you have an individual that didn't enter on a passport or properly or cross the border illegally, that's going to be the first contact they have with an independent body, right? It'll be the school system. So the school will be able to give you a document that shows his or her date of enrollment, which will put him in the United States, hopefully before the age of 16. And that's what you want to show. You can also get this evidence from immigration documents. There's something called the NTA, or the Notice to Appear, and it's a document that will include the individual's name, date of birth, and an estimate of when they entered. If it doesn't include a date when they entered, it will be signed and dated by the officer who has caught them, so to speak, and that date will serve as a controlling date and evidence that they were here, hopefully, before the age of 16. If it doesn't show that, then that person would be ineligible. Also, hospital records and travel records, those are really good pieces of evidence to show evidence that you've been in the United States prior to 16. This one is probably the toughest requirement, and this is where your skills as an attorney are going to be really useful and helpful to these applicants. They have to show that they have lived continuously in the United States for 5 years. That means as of between June 15, 2007 and June 12, 2012, or till today, that they have actually lived in the United States, so 5 years. We're looking for at least one document for each year. If the person can show you one document for each year, they've met the threshold and they should be assisted with the application. There is an exception if an individual has traveled briefly outside of the country and that absence has been short and reasonably calculated to accomplish a purpose, and it wasn't for a criminal purpose, that individual can go forward, and the DHS USCIS won't deem their absence to have broken the continuous presence requirement. We will have a sample affidavit for you to assist the individual should you have a kid who comes in and meets that definition. More important than that, the person has to have been in the United States physically on June 15th, 2012. Does that mean that if that individual doesn't have something dated June 15, 2012, they are ineligible? No. If you have a document that places that individual here June 1st, or a document that places that individual here July 2nd, and that document has been reproduced in May or in April, that is going to be sufficient. They are going to accept circumstantial evidence to show that this particular requirement has been met. So what we're looking for is pieces of evidence in or around June 15th. If you happen to have a piece of evidence like like a cell phone bill, some of them will come in with printed cell phone bills where they are clearly under their name and they have calls coming in and out on June 15th. That's exceptional. That's not going to be the case for everyone. That's obviously like the best situation. But you can have an assortment of other things. For instance, typically these individuals will be living with their parents. So you might use parents' rent receipt or utility bills, employment records of the kid or the young adult, school records, when you are evaluating a school record, be sure that whatever you're looking at from the school includes the name of the school, the date of enrollment, and the current date, where he is in terms of the educational level. So is he a first year in college? Is he a freshman in high school? That's important. Another good piece of evidence that we see often is the immunization records. Less often you'll see a lease or bank statements, but you might see that. And you might also see that a young person has a U.S. citizen child, and so that child's birth certificate will be really good evidence of continuous physical presence. If there is a child involved, then prenatal care is also going to be good pieces of evidence that you're going to want to show if it's a female, as well as the other pieces of evidence, which include transactions, bank transactions, and money orders. This one is critical. If you were here on June 15th and you were here legally, you are not eligible for DACA. So for instance, if you were an F1 student that was eligible for an F1 status on June 15th, you cannot apply for DACA. Okay, so you have to have been out of status on June 15 in order for you to actually apply, all right? How do you show this? An applicant who enters without inspection or across the border will not have to show this, right? Because it's clear that they don't have permission to be here. But someone who did come in legally will have to show evidence. And so that means we're going to want to see the I-94. The I-94 is the arrival and departure record that we've talked about. Or you're going to see things like a final order of removal or exclusion or deportation, which may have been issued to the individual, as well as an NTA, which is that sort of, it's the equivalent of an indictment for immigration purposes. You know, in criminal court, you get indicted. In immigration court, they give you an NTA or a notice to appear. The final criteria that must be met is that the person be enrolled in school at the moment, or have graduated from high school, or have obtained a GED certificate. If they have not done any of those, and they have served in the military, and they were honorably discharged, then that person will also be DACA eligible. So for your purposes, our first clinic on September 10th will include individuals that are at a community college. Those individuals, this is not going to be something that affects them because they're going to be clearly either enrolled, currently enrolled, or recent graduates of that school. But in the other clinics, this may be something that you have to look into. And so that means that, how do you show this? You need to show a high school diploma. So when you begin to review the evidence that the individual brings, be sure to be looking for a high school diploma, a GED certificate, or some sort of a transcript that shows that the individual has been enrolled in school and graduated or is currently attending school. Some of the individuals will produce a letter of enrollment. Just make sure that it includes those key pieces of evidence, which include the name of the school, the date of enrollment, and where they are in their course of study. Occasionally, there will be individuals that aren't enrolled in GED or high school classes, and they're enrolled in alternative forms of education like literacy classes or career training programs. If they are, then it's on the applicant to show that that particular program has demonstrated an effectiveness with the actual attendees of the school. That means that they've actually successfully placed individuals in jobs or successfully helped them pass the GED exam or successfully helped them pass an examination to get to post-secondary school or GED certificate. If they were honorably discharged, then there's a form that you're going to need to see, which is the DD-214 from the military. If the person is enrolled in an alternative form of program, then this is what you're going to need to be looking for, things that show the length of a program's existence, the track record of helping people to achieve whatever it is that they're promising to achieve. So if it's a high school diploma, you're going to want to see those statistics. How do you gather this? Typically, this is going to be on that program's website. So this will be their recruitment tools. This will show a trend toward effectiveness. And again, it's on the applicant. If the applicant did not bring those pieces of evidence to the clinic, then you need to advise them that they need to return to the next clinic with those documents. And now Maria Navarro is going to talk to you about what disqualifies you.
Okay. So thank you, everyone, for coming. As Lynn said, I work in the immigration unit at the Legal Aid Society, and we specialize in the intersection between immigration and criminal law. So I want to talk to you about what DHS has said are going to be the various criminal bars, but also some offenses that may not be bars, but will be considered by DHS at a discretionary level and what to do. You will, as a volunteer, you're not going to need to know all of this in detail, but you want to red flag all of these things. You want to be sure that the clients understand how serious it can be, that it can not only lead to a denial of the application, but can lead them to become, as Barbara said, the different priorities that they have, it can lead them to become a #1 priority, deny the application, and place them in removal proceedings. So the last thing we want to do is put someone in a worse position than they were when they walked in the door. So the government has listed certain things that are clearly bars, and that's what's listed now on the PowerPoint. Any felony, any significant misdemeanor, 3 or more misdemeanors of any kind, or anything that poses a threat to national security or public safety. And before we get into what does this all mean, I wanted to give you just a general background on how criminal law is handled under the INA, because it comes as a surprise to even many criminal defense practitioners that things that seem not serious at all under the criminal law can become very serious under immigration law. So we have a lot of clients who come in and say, oh, it was just a misdemeanor, it was just a violation. Well, something may have not been treated not serious in criminal court and now is going to be very serious in immigration court. So we want to be sure that people understand that, and if there's any arrest, any contact with the police, that you tell the person. You'll have an immigration specialist that you can reach out to and see what kinds of records that we would want to get before advising this person whether or not to go forward with their application. And as you can see, a criminal conviction is defined in the INA under 101A48A, and it's much broader than it generally is under criminal law. So anything that is a formal judgment of guilt is a conviction, but also where adjudication has been withheld, if a judge or jury has found the non-citizen guilty, or the person has admitted sufficient facts to warrant a finding of guilt, and there has been some form of punishment. That will be found to be a conviction under immigration law. And what does a form of punishment include? It includes incarceration, including suspended sentences, probation, community service, any drug or rehabilitative programs, any adjournments with no new arrest conditions, suspension of a driver's license, and any costs, fines, or surcharges that the court may have found for them. And so, to give you an example, a formal judgment of guilt, I think everybody would know that that's a conviction. But a deferred adjudication, and those are common where the court wants to have some sort of ameliorative treatment of the person and let them, for example, in New York, if you get arrested and you're being charged with a felony and it's a drug-related offense, a lot of times the court will give the person a chance to complete a program. If they complete it successfully, they'll come back, and maybe it'll be pled to a lower offense, a misdemeanor, sometimes a violation, rarely, but sometimes can be dismissed. And that person is going to walk out of criminal court thinking that that is what is the final disposition in their case. And in other than immigration world, that is true. But for a non-citizen, under this situation, the initial plea that they took to the higher offense is what's going to count for immigration purposes. So that we want to be sure that you review any of the records that anybody has on any arrest that they had. In addition, you'll see that a criminal disposition that was vacated or expunged can also be considered a conviction. There are cases where if a conviction is vacated in criminal court and it's for rehabilitative purposes, it may still be considered a conviction under immigration law. So again, we want to look at the certificate of disposition, and we may need more information. We'll talk about that in more detail as we go forward. A court-martial is going to be considered a conviction under immigration law. A juvenile offender is also. Things that are not convictions, and family court dispositions, deferred adjudication where there is no plea or admission of guilt. If a conviction is on direct appeal, that will not be considered a conviction. Anything that's vacated where there's a legal defect should not be considered a conviction, and juvenile delinquencies and youthful offenders. However, even though they are not going to be considered convictions, they can be considered on discretion. And so you're going to see some people who maybe do not have a bar to apply to DACA, but may pose some risk. And just to give you an example, at our office, we've been doing a number of clinics already. We've seen about 650 people at this point. And there was a young man who came in and he had a disorderly conduct. He had his certificate of disposition, and it looked fine. He looked like he was good to go. He had gone through the pre-screening, through the application assistance, and now he was at the final stage. And when we were reviewing it, I noticed that on the dispositions, you also see what the charges are. And he was charged with public lewdness. And under immigration law, for those of you who practice, any sort of sex type of crimes are going to be taken very seriously. And so I asked him what the circumstances had been, and he said, well, it was just urinating in public. And I said, okay, that's fine. And then I just went through with him, again, why we were asking, because it's possible if somebody sees that charge, and through this process, everyone is going to be fingerprinted, so they're going to come up with all of these. And if any of you have seen rap sheets, a lot of usually the charges will come up, and they could ask him for the record of conviction. And that's what we're going to move on to next. So they could ask for the complaint. And two things is, one, they're going to see whatever it was he was charged with, and if it turns out to be very different than what he's saying, that could be a problem as to his credibility. And also he's going to have to explain, how is it that they're charging you with something and you said you were just urinating in public? And at that point he asked me, could we move over to the corner, and he told me he was actually caught having sex with his girlfriend, and that it was a whole nother story. So we stopped him there and told him he needs to get the records, and we set up another time for him. But, you know, up until this point, he was saying the same story. He said that that's what he's always said, and it's never been a problem. But it could really be a problem here. And as Barbara will go through with you a little later, you'll see in the application, if you answer yes, if you've been arrested, they say in there that you should be submitting some records. And what does that mean? The record of conviction includes the complaint, indictment, a certificate of disposition, plea minutes, sentencing minutes. Not as part of the record of conviction, generally a police reports and pre-sentence reports. And again, this isn't something that you will be making a decision on, but once you have red flagged it, we will have to deal with the client and go over with them, what is it that you want to submit? I think it's all going to be a case by case, and we'll talk a little bit more about what we would do in these kinds of cases and what you should be looking out for. So going back to what are the bars. A felony is going to be a bar, and it's defined as anything punishable by imprisonment for more than 1 year, and that's regardless of what it's classified under state law. And then a significant misdemeanor is an immigration term that DHS has come up with for this purpose. So what does it mean? It's defined as an offense punishable by a maximum term of 1 year or less, but more than 5 days, and meets the following criteria. So on the left-hand column, it's regardless of the sentence imposed, anything that involves domestic violence, sexual abuse, burglary, driving under the influence, unlawful possession of a firearm, or drug distribution. These were not specifically defined, and so we have looked to how they have been otherwise defined. And as to domestic violence, generally we're looking at any injury to a person or property with a particular kind of relationship. And in the Immigration Nationality Act, they define the domestic violence under 237A2E, and it looks to how the family courts define families. So this can include spouses, but it can also include people who are living together as spouses but are not legally married. It can also include siblings, parent-child relationship. So if you see anything that looks like it could involve anything defined as domestic violence, it's a red flag, and you should call the immigration specialist over and probably will need to get the records on this to determine whether or not to move forward. Sexual abuse or exploitation generally includes rape, sexual abuse of a minor. Any kind of sex crime is going to be a red flag and would have to be reviewed before giving advice to the applicant. Burglary is generally going to just be defined, we believe, by state and federal law. Driving under the influence, originally in what the government did when they came out with deferred action and the instructions, they also issued the FAQs, which are listed online, and you can look at them, the frequently asked questions, at uscis.org. And under the original FAQ, they've issued, I think, 2 sets now. It said under the influence of alcohol or drugs, so driving under the influence of alcohol or drugs. In the second FAQ, they didn't say alcohol or drugs, so they just said under the influence, driving under the influence. So we're just in being cautious. There is a New York offense, driving while impaired, which can include other substances besides drugs or alcohol, and as generally viewed. And so anything that is going to involve what looks like a potential DUI is going to immediately be a red flag. Possession of a firearm, again, we think is just as defined under state law. Drug trafficking, and for all of these, generally under immigration law, attempts at the same offense are treated as if they were the same offense. So an attempt to on drug distribution is the same as drug distribution. And so any of those are going to be red flags and could mean that the person is not going to be eligible for DACA and should not move forward with their application. Any misdemeanor offense where the individual received a jail sentence of more than 90 days, it could be considered a significant misdemeanor, or will be. And there we also want to note that there are some New York violations that may be considered significant misdemeanors. And in particular, harassment maybe could fall within domestic violence. So something that, as an example of something that wouldn't be considered a criminal offense under New York law, could be considered a significant misdemeanor, we believe, under the DACA definition. The other grounds that are bars are multiple misdemeanor convictions. So convictions for 3 or more misdemeanors of any kind, and it's defined as an offense punishable by a maximum term of 1 year or less, but more than 5 days. They cannot have occurred on the same day and arise out of the same conduct, and the jail sentence imposed is 90 days or less. And so we think that, again, a violation in New York could fall within one of the multiple misdemeanors if you have several. And I think, Barbara, we saw somebody at the clinic you went to who had 3 disorderly conducts that possibly would fall within this, so we pulled this person aside as well, and we're going to do a further review on this. So the government has stated that minor traffic offenses are not going to be considered under the multiple misdemeanor or significant misdemeanor, but they will be considered under the discretionary factors to be considered. Also, not automatic bars are going to be expunged or vacated convictions. And youth offenses are also not automatic bars, juvenile delinquencies and youthful offender cases. Again, we saw somebody at our last clinic who is a young woman who had a juvenile delinquency when she was 13 years old. Since then, she had finished high school, she went to college, she had outstanding recommendation letters, and she's currently volunteering at New York Cares and another organization. Unfortunately, the juvenile delinquency that she has involved an assault. It sounds like it was a fight between her and some other girls who had attacked her cousin while they were walking home. Her disposition involves a girl was stabbed, and she was the one who was accused of doing the stabbing. She says she didn't do it. Unfortunately, it is a violent act that we think could be problematic for immigration purposes. And so she is getting her full record. In her case, based on what we've seen so far, we do believe that she is somebody who should go forward with her application. But we've gotten somebody from a firm that we've been working with who's going to work with us to really beef up her case. So rather than just submitting the dispositions, she's going to go get more letters of recommendation from the current places where she's volunteering, and we're going to work with her to write an affidavit to explain what the circumstances were and how she's changed her life since then. And she understands that what the possible consequences are. She is, and I think through this clinic, everyone is going to be pre-screened to make sure they're not eligible for any other more permanent form of relief, to make sure that we don't miss that. She unfortunately is not, and if it gets denied, we do think under prosecutorial discretion that they hopefully would not put her in proceedings given everything she's done with her life. So even if they deny it, that she would not be deported. But it is a risk, and it's something that she needs to be aware of, she is aware of, and has to then make a decision about whether she wants to move forward with this application. So you will have at the clinics, when people come in, and you have a red flag, they need to get the first step is going to be the certificate of dispositions. So we've created this flyer so everyone knows in the 5 boroughs where they need to go and how to get them. We've also seen a number of people who've jumped the turnstile, and you'll see on the bottom they can go to the MTA also to get a disposition letter there. I don't think it's in your package, but you'll have it at the clinic. The other piece of information on the discretion issue is the people that they have said that they're also going to look out for are people who have had gang membership, and they haven't defined whether it's current or past, or what kinds of documents that they're going to use. And on this issue, we also saw somebody who had been arrested 3 times, and he happened to have his rap sheet with him, and the charges included allegations that he had been part of a gang. All of them were eventually, he pled to, I think one was dismissed and 2 others were disorderly conducts, which usually are not a problem. But because of the gang membership, we've pulled his aside and also wanting to see, what are the positives on his side, and to determine with him whether he should be going forward with this application or not. And any participation in criminal activities or activities that threaten the U.S., could also be factors that they use to deny applications on discretion. There is an exception that they have said would be exceptional circumstances. Again, they didn't define, it's not defined what that means. We're looking at where in the Act, in other cases, they've used similar terms. And so we think that, and it's unclear whether they mean exceptional circumstances as to what happened on the date of the incident for whatever the person was arrested for, or whether, given their whole life and the totality of the circumstances, those are exceptional circumstances. So it's a case-by-case review, and if we're gonna advise somebody to go forward, we would want to include some of the things that are listed here, and we would go through with them what are the other positives they've done with their lives, what happened, why were they arrested, and as we are doing with the other young woman is, working with them to explain all of that. Perhaps they were a DV victim. Many people that we've seen have been working for a long time. They file taxes, they have strong family ties here. And so that would all be part of what we would include in their package if it was a case where we decided to go forward. And this is just to give you an idea of how the clinic should work. And in the first step are the immigration screeners. So they're going to be the ones who are going to meet with the people first. So these are the immigration screeners are going to have an immigration background, and they're going to be looking for whether the clients are eligible for any other form of relief. And generally, even if they are, we would still go forward with this application because it's not going to bar the other forms of relief. But again, because you want to be cautious, you want to make sure it's all the truth. It's all going to be consistent so that even if they get this now, that it's not going to harm their future applications potentially. You also will be able to do some appropriate referrals if they are found to be eligible for other forms of relief. The most common forms that we've seen so far are U visas for people who've been the victims of crimes here in this country. They may be eligible for a U visa, which after 3 years could lead to a green card, so a more permanent form of relief. The other common thing we've seen is special immigrant juvenile status, so some people who are here under 21 who may have been abused, abandoned, and neglected by at least one parent. So we've been making those referrals. After seeing the screeners, they will then go to you as a volunteer attorney to go through application assistance. So literally, you'll go through the application. I think Barbara's going to go through that with you. And then the final review to make sure the application has been filled out fine and that there aren't any issues on eligibility. So as screeners, we're going to ask about all contacts with law enforcement. Again, to be sure that people understand, even if it's been sealed, dismissed, a summons, a violation, anything that has any contact with the police, we want to make sure that we don't miss. And it's important to explain to clients as well the consequences of lying on these applications, because it could lead to the denial of the application, and also they could be treated as a priority under immigration enforcement. So they could be then forwarded again to be put in removal proceedings. And even if it doesn't happen now, it could be that it affects them in the future. So we really need to explain to everyone that comes through how important everything that you put in this application is, because it's going to be part of what's called your A file, and it sticks with you all the way through until hopefully you become a citizen. It could result in criminal prosecution and removal from the U.S. And so points to remember, I think you can't be hasty and don't assume anything. Take your time in asking these questions. They're that important that you want to be sure the client understands before they move on. We're going to ask to see all the criminal documents, asking about the underlying facts of the case. There may be people who come in and were arrested a long time ago. They don't remember exactly where. It could be in another state. Those people we would recommend, and we're going to be taking some referrals from your clinics, to get an FBI rap sheet before they go forward. They cost $18. They do take 4 to 6 weeks, but there is no deadline for DACA, and so it's much better to take your time and be sure you're eligible before moving forward. And I think that's it, and I'm going to turn it back to Barbara.
So let's talk a little bit about what's going to happen the day of the clinic and what the general application process is. There is going to be a $465 fee that's associated with DACA. There isn't a fee waiver, but there is a fee exemption. We will not be handling that part at our clinics, but we will give them or give the attendees information so that they can do that on their own. One of the reasons we're not doing it is because under the DACA FAQs, they have to get approval of the exemption before they can actually file for the DACA, and the approval can take several months, and we only have the fall to do it. So we're going to be giving them how-to guidelines so that they can do that themselves. It is available, but for very, very limited circumstances. So not only do you have to show that you're under the poverty line by 150%, you also have to meet one of those 3 discrete categories. You are either under 18, homeless and in foster care, or lacking parental support, or have a serious chronic disability, or have medical expenses that exceed $25,000. That's a very small group. The DACA application consists of those forms on the PowerPoint. That includes a G1145 and a form called the 821D for DACA application, the work permit, or what we call employment authorization. There's also going to be a 765 worksheet, and we are also going to be giving the attendees a next step worksheet so that they know what they have to do with the forms you've helped them complete once they leave the clinic. You're also going to be given a checklist so that you can be sure that you've done everything that's required of you in terms of preparing the application. And the final reviewer is going to hand them certain advisals, which include the travel advisory and a reminder on the criminal bars. Volunteer attorneys are going to be assisting in the preparation of those 4 forms. The 1145 is an e-notification, and we'll start with that one. More importantly, these applications are going to be completed by hand, so the applicants or attendees should be writing them, and it's critical that you tell them that they need to write legibly and in black ink. If they make a mistake, they cannot scratch it out or white it out. USCIS is using a machine that picks up whatever's under the whiteout, so they're requesting that if you make even one error on one sheet, they have to do the whole sheet over. We don't want them to have misspellings on their approval notices, and we definitely don't want them to have errors on their work permits should they get approved. So we need to sort of really strongly encourage them to write very neatly and in black ink to avoid that. So this is what the relevant part of the form looks like. The forms are in your materials, and the forms start on page 11. Pardon me, page 9. So the 1145 is your page 9. The relevant portion of it is at the bottom. If the person has a working email address or a cell phone number, this is a really good form to get them to fill out because they will be given immediate response from USCIS. They will be told it's been received immediately. So this is a good form to get them started with. With the next form, it's the 821. You'll notice that the top one, the top portion, is not to be completed by you all or by the attendee. It's for the use of USCIS. So the first part that you're actually going to complete, oh, what did I do? Sorry about that. Is going to be part 1, which starts with information. If you're following me, I'm on page 11. I want to talk to you about certain pieces of the application that are going to be critical. One of the critical pieces are going to be the removal proceedings information. So one of the questions that you're going to be asking the person that you are completing the application with is whether or not they have been in removal proceedings. If the answer is yes, then you need to get information from them. You need to find out whether or not they're currently in removal proceedings, whether or not the proceedings have been administratively closed, whether or not it's been terminated, or whether or not they have an order of removal. If they have been in removal proceedings, we need to see some documentation from the immigration court. If they do not have that with them, that's something for you to note when you send them to see the final reviewer, okay? Because they need that information. If the intake said that they were not in removal proceedings, we want you to ask again. We want to build as much redundancy into this process as possible. So as Maria indicated, sometimes people say the same story 2 or 3 times, and it's not until the 4th time that somebody asks them that it dawns on them, maybe this is an important detail I want to disclose at this point. So we want to have as much redundancy into this process as possible. So confirm the response on the intake is actually accurate. You have a copy of the intake, and the intake is between pages 1 and 6. If the individual indicates that he is not sure whether he was in removal proceedings, then you want to make sure that he finds that out. So you're going to give him that 800 number if he has an A number. If he doesn't have an A number, then that's a different story. And at that point, you want to raise your hand, and one of the immigration experts will come to your aid and answer one of your questions, okay? Oh, I did it again. Sorry about that. So what's an A number? So an A number is a unique identifier that's given to anyone who's in removal, who's had any removal interaction with immigration authorities. If you've applied for a benefit, they've probably given you an A number. They will certainly have given you an A number. Another thing to note is they will also ask for the person's social security number. It's important that you make a distinction between a social security number and an ITIN or a tax ID number. If all they have is an ITIN, you do not include the ITIN as a social security number because it is not a social security number. With respect to countries of birth and citizenship, sometimes people have dual citizenship, so they may be born in one location and have citizenship in other places. So make sure that you compare the birth certificate and the passport, and if they're from different places, make sure that you note them. Also, critical, number 9 has to have U.S. on it. They have to have currently been residing here in order to be eligible for DACA. The entry information is critical. Remember at the beginning, I had indicated that they have to have shown that they entered before the age of 16 and before June 12th, 2012. June 15th, 2012. So this is why that question is critical. It's important to note that people who did not come in legally will often have to estimate this date because they don't recall exactly what day they came in. We're talking about something that may have happened many years ago, and they don't have an I-94, which is something that you can readily identify. So you will probably have to estimate. And so these are examples of what one might put on the application. They might say approximately January 2001. They might say Mexico or Arizona border. I wasn't quite sure where I entered, okay? Those are all appropriate answers if the person is unsure. Okay, and that's typically going to be of EWIs or what we call EWIs, and that just is short for entry without inspection. That's someone who came across the border. Status at entry is referring to how they came into the country. So if the person came in through a border and not legally, you are going to have that individual write EWI or entered without inspection. If that person came in as a visitor or as a tourist, that person will be a B1 or a B2. An F1 is a student, and we're going to go through examples of what those visas and I-94s look like. Remember, that person has to be out of status on June 15th, 2011. So when you're looking at the I-94, you're looking for something that is expired prior to that date. So this is an example of a B1, B2 entry. So if you look at the visa, where it says visa type, can you see that? On the visa stamp, it's all the way on the top right-hand corner. It says visa type class B2. That's where you get the classification. You're also going to note that under it, there is an I-94 card. It says I-94 departure record under the number that starts with 74. The number that starts with 74 is actually the I-94 number, and some of the questions on the form are going to specifically require that number, so that's where you find it. This example shows that this individual entered on September 13th, 1991. And was admitted as a B1 until July 10, 1993. This individual would be eligible for DACA, assuming all other things are equal and the person isn't over 31, right? Because she was expired as of June 15th, 2012, because her date of expiration was back in 1993. So that's how you look at this document, and you confirm that the person is either out of status or was out of status on June 15th, 2012. So you may have more than one type of I-94 come across your desk when you're doing these clinics. If it's a white card, it'll be an I-94, and that's for countries that require visas. You might also see a similar card that is green, and if you see the green one, that's for visa waiver countries. So if you're from France, you don't need to come in with a visa, but you do have to have an arrival and departure record. So you may see a green one. You read it the same exact way. You look at what the status of the person coming in, and it says B1, when their entry date was, and when their date of expiration is. You want to also confirm that the name matches the passport and birth certificate, as well as the date of birth. If there's a discrepancy, you're going to want to raise your hand and talk to an immigration attorney. An example of an F1, we're putting it up because the F1s are a little bit different, right? The F1 typically gets what's called a DS. I don't know if you could really see that on the materials, but you see how it's a handwritten F1 and then a D\S. The DS stands for duration of status, and you have to calculate that expiration number. The way you calculate the expiration number is with reference to a form I-20. In your materials, there is a form I-20 sample. It is on page 31. If you look at question 5 on page 31, it will say the student is expected to report to the school no later than a date and complete studies not later than a date. That final date where they are expected to complete their studies, you must add 60 days because they get a 60-day grace period to that date. So this person would be out of status not in May 15th, but July, because they'd get the month of June and the month of July. So this person would be July 15, 2011. So this person would be eligible for DACA. Now, if it had been 2012, then this person would not be eligible for DACA because they would still be in status. Everybody with me so far? Okay. So that's what's different about the F1. You're still going to read the numbers up at the top, which are the I-94. It's still going to tell you what the date of entry is, and the expiration date is what you have to calculate, okay? And this is sort of just a review of what we've discussed, how to get the I-94, the status at entry, and the departure date. You're also going to be asked the port of entry. So this individual came in at WASH, 250 WASH, which we'll say is Washington. And so when you get to the question that asks for the port of entry, you would simply include WASH. If a person is not a college graduate, or pardon me, is not currently in school and is not a high school graduate or GED graduate and is trying to qualify based on their military service, then these questions have to be answered. He has to be able to articulate the branch, the service start and discharge date, and you can get that from the DD 214. If you don't have that, then you would make a note of that so that when he goes to see the final reviewer will remind him and include that on the next steps document that he's going to take with him so that he knows what the following steps are. These are critical questions in part 2. It is, I arrived in the United States before June 15, 2007. That's critical because they need 5 years of physical presence. So the answer to that must be yes in order for them to be eligible. Remember, the individuals will have been pre-screened before they see you. That means an immigration attorney has deemed this person eligible. So when you're preparing this application, that should be yes. If you mark off no, then that person's application will be kicked off because he will not be eligible. And also, you also have to have a yes for the second part of that question, which is I've been here continuously since at least June 15 of 2007. This is the arrest question. We're just putting this as a reminder. The screeners, and we have some screeners here and final reviewers here as well, should carefully review the intake and ask again whether or not the person has been arrested. Any arrest should be something that is further explored. The facts underlying the arrest should be sort of discussed with the individual. And we will have on-site criminal experts as well as someone from the Legal Aid Society on the phone. If a volunteer identifies, if you identify an arrest, that is to say, the person got through the initial screening saying, no, I've never been arrested, and when you talk to him, he then says, you know what, there was a situation where I was in the back seat of a car that I didn't tell the screener about, raise your hand, and the screener or someone with criminal experience will come to have a conversation with that individual because we want to make sure that he's properly screened. It's on the front end and the back end. It is not a situation where you will be acting as a representative. Therefore, we will not be entering a G28. So when you get to Part 5, you should check off no. Our forms are pre-printed with that message, and that message is on page 15. It says pro bono group assistance event, no G28 submitted consistent with 22811 USCIS statement of intent. We also make the attendees sign a limited scope agreement so that they understand that your representation or assistance of them is limited to that hour that you spend with them completing the application. Before they sit with you, they will have a very clear understanding that they can't call you up with follow-up questions. However, while they are in front of you, it's important that you walk them through each question and answer every question that they have. If a question that they pose to you you do not know the answer to, raise your hand. We'll have people there floating who will be able to answer those questions for you. We recommend that you not physically write the application for the applicant. Allow them to do it. One, it gives them ownership over their own application. If you see that they have really, really, really bad penmanship and you feel like you need to, then it's fine. We recommend that you allow them to do it. Make sure that the individual signs the application and dates it. The next form that you'll be assisting with is the work permit. And similarly, the top portion of this is for USCIS only, so don't complete the very top portion. But if you notice, right above it, it says, right below that one box, it says, I am applying for, and you have 3 check boxes. If it's the first time an individual is applying for an EAD or a work permit, you need to check off that box. If this is the second time or third time, then you would check off or renewal, I should say, renewal, which is the third box. The EAD is also going to ask you about manner of entry. Manner of entry is the same as status of entry. They just named it differently on this form. So for that question, the answers will typically be either entry without inspection, F1, B1, depending on whatever's on their passport and visa if they came in legally, or if they tell you that they came across the border without documentation, you would put E-read as well. Question 16 must be answered with C33. Our forms are pre-printed and we'll have that already. You do not answer question 17. It's not applicable. And of course, remind the individual to sign and date the application. You will not be completing the preparer's portion because, as I said, we're not submitting G28s. Okay, so what happens after the clinic? You've helped this individual, you've completed the actual paperwork, you've reviewed the documentation, the person is ready to submit it. At that point, the individual is going to be shown to a final reviewer. The final reviewer will be an immigration attorney, and that person will give him advisals that are necessary for him to understand the processing of the application. For instance, he will be told, and there will also be a checkout, like a form, so he will have something that he can take with him, so it's not sort of like an exercise in memory. He will be told that they will receive a receipt from USCIS within 4 weeks. He will be advised of the biometrics appointment. The biometrics appointment is just a fingerprinting appointment because as Maria had said it earlier, part of this is to get the people printed to make sure that what they've disclosed on the application is actually consistent with what the FBI knows of this individual. So they have to appear at the appointment. Approvals, we are told, will take several months. DACA approvals are required before the EAD is actually issued, so we anticipate that it will be quite some time before the work permits are actually issued. And again, deferred action is renewable after 2 years. These are all advisals that will be given to the individual. If they're going to renew in 2 years, they need to have shown that they have either completed their studies if they had indicated that they were currently in school, or shown measurable completion or getting, like they're getting closer to that goal, so to speak, toward graduating. And they'll be given other advisals like the travel advisory. These individuals should not be traveling while the DACA application is pending, and they are eligible for certain public health insurance benefits that we want them to be aware of. There is one more sheet. The 765 is the worksheet, and what's important about this is that unlike every other document which you will be working with, which will require evidence, this particular worksheet does not require any supporting evidence. This worksheet will ask the individual for income, it will ask the individual for expenses, but they do not need to demonstrate it. They don't need to show proof of it. If the individual is in one of these categories, for instance, the individual is a full-time student, or he's living at home with his parents, or if there are any other significant expenses, so maybe he's disabled or caring for a sick relative or anything of note, that should be included in a sentence, right there in Part 3, where it says if you would like to provide an explanation of the above information. Generally, a sentence like the one we posted up there, I live with mom who supports me, I'd like an EAD or work permit so that I can work to support my family, myself, save for college, whatever their reasons are, will be sufficient. If that individual that you're preparing the application for doesn't meet any of those categories, leave it blank, okay, and just stop. These are the questions that are going to be on the worksheet, which is basically your annual income. Make sure that the person is multiplying their income by 12, so each month. Make sure that their expenses include, the typical things such as rent, utilities, commuting, medical expenses, tuitions. Typically, the assets will be zero, assets like, houses, cars. So typically, that will be zero. The volunteer attorneys, the people who are actually completing the applications or assisting in the completion of the applications, should organize the person's documents into this order. So it should be the first form, which is the 1145, the 821, the 765. If they've brought their money order with them, make sure that it's stapled. If they've got their passport photos, you're going to want to make sure that their names are on the back of the passport photos. And then you're going to want to put their supporting documents in order. We're going to provide you dividers so that you can organize it, so that identity documents have a cover sheet, and continuous presence documents have their own cover sheet, so it looks organized. Final reviewers will take that packet and review it thoroughly for legal sufficiency, much in the same way as you did, because we want to make sure that we build in redundancies. The idea is that if the screeners miss something, you'll catch it, and if you miss something, the final reviewers will. Now we're going to talk very quickly about other forms of relief. Before the individuals come to sit with you, they will have been reviewed, they will have been screened by an immigration attorney, and they're going to be screened by the things that I'm going to be talking to you about. I want to talk to you about it so that you have some idea of what they've been through before they sit with you, and since you'll be looking at the intake in order to complete the form, you'll have a better idea of what kinds of questions are red flag questions. So one of the things that you might, that they will be screened for is the T, non-immigrant status, and that's available to people who are victims of severe forms of trafficking in person. Typically, this is going to be labor or sex trafficking, and There are certain requirements that the person has to comply with. They have to have cooperated with reasonable requests for assistance of a law enforcement official in order to be eligible. And they also have to show that they would have suffered extreme hardship involving unusual and severe harm upon removal. The person who gets a T visa will be able to have that status for 4 years, will have work permit authorization, but more importantly, they will be eligible to apply for permanent residency. And that's what makes this such a special category, because it's a permanent relief as opposed to DACA, which does not give them status. So what is trafficking? So these are the definitions. Sex trafficking is when a commercial sex act is induced by fraud, force, or coercion, or in which the person induced to perform such an act is under the age of 18. It can also be recruitment or harboring, transportation, or obtaining of a person for labor services. So if the person was brought into the United States with these things in mind, that person could very likely be a victim of trafficking. Typically, you will see individuals engaged in these types of work, which include domestic work, hotel, tourism occupations, massage parlors, sex work, things like that. Typically, victims of trafficking will have been detained, physically assaulted, and sex assault is also a common marker among these. And typically, the trafficker will use their lack of immigrant status against them as a tool to control the behavior of the individual. Another visa or another non-immigrant status that can be obtained for an individual is the U visa, and this is specifically reserved for victims of crimes. It has to be a certain subset of crimes, and typically you have to show, well, you always have to show that the person suffered substantial harm as a result of one of those crimes, and that you have actually helped or cooperated with law enforcement in order to get the perpetrator. And you also have to show that you've suffered physical or psychological trauma. You also have to show that you're admissible, but there are a whole lot of waivers available. And of course, the purpose here is to encourage people to cooperate with law enforcement to keep our streets safer. This person, similar to the T visa, will be able to live and work in the United States for 4 years, and it does also provide a path to permanent residency. They will also be eligible for public benefits, so this is a really great way of, a great venue for people who qualify for it. And this person, if we identify somebody that's eligible for this, we definitely want to give this person a referral so that they can actually get the permanent relief that they could get, rather than just stay with the DACA limbo. And a petitioner here can also apply for derivative status for family members, unlike in DACA where there is no family reunification. With the U visa, you can bring in other family members. These are the types of crimes that typically will trigger a U visa, that qualifies someone for a U visa. It will include things like domestic violence, rape, torture, trafficking, incest, sexual assault, prostitution, and the like. Again, any attempt to commit these crimes or those that are substantially similar are considered crimes for the purposes of the U visa. Another form of relief that will give somebody permanent residency is VAWA, but this is specifically reserved for people who are the spouses or children of abusers who are either U.S. citizens or lawful permanent residents. If you are the spouse of an abuser, you can actually cut the abuser out of your petitioning process, which means you no longer have to be with an abuser in a captive in a marriage in order for him to legalize you. You can do it independently. If you're a child of an abuser, you can also do this independently. And you can do this between the ages of 21 and 25. 25 if you're a child, and the reason why you haven't already applied is because it was tied to the abuse. And of course, those individuals will also get work authorization. It does require a legal marriage. It has to have been a good marriage, a good faith marriage. It couldn't have been entered for immigration purposes. You have to show joint residence, and you also have to show that you were a victim of battery or extreme cruelty. And you have to show that you have good moral character. The good thing about VAWA is that children can apply for themselves or as derivatives of the mother or the father, as the case may be. It's called VAWA because it's Victims Act Against Women's Violence, but it's actually also allowed to have, men. If men are the victims of domestic violence, they can also benefit from this form of relief. Asylum is also a form of relief that can lead to permanency in the United States. In order for someone to qualify, the person has to have been fleeing their country because they feared persecution on one of those protected grounds, and those grounds are race, religion, national origin, political opinion, or membership in a particular group. Examples of particular groups include sexual identity or HIV. So if someone is HIV positive and the country that they're fleeing from has a history of violence against people who are HIV positive, that person could conceivably be part of that particular social group and be eligible at least for asylum. If you are over 18, there is a 1-year filing deadline with this, so it's critical that if we identify somebody who's eligible, we sort of get that person referred as soon as possible. This person will be able to petition for their spouse and unmarried children under 21, unlike DACA, and they will be eligible for a green card after having asylum for a year. SIJ is something that is sort of hand in hand with DACA, and if you are under the age of 21 and you've been declared dependent by a court, a juvenile court, or placed in the custody of a state or an individual, and reunification with one or both of your parents is not viable due to either abuse, neglect, or abandonment, or a similar basis in law, and you have a judge make a finding that it's not in your best interest to be returned to your country of birth or citizenship, then that individual may be eligible for SIJ, and we will have screeners that work with SIJ all day long to make sure that if we see someone who qualifies for that, we give them the appropriate advice and referrals. This is important it's important to note that for an SIJ, it is a 2-step process. It will require a family court order before the person becomes SIJ eligible in terms of immigration. They can't go forward on the immigration part of it if they haven't already been to family court. Sometimes we identify people who might be eligible for U.S. citizenship and don't know it. So sometimes, in addition to being born a U.S. citizen, you can acquire citizenship in other ways. And so there are 3 other ways. Naturalization is when you follow the path and you get a green card, and after you've been as a green card holder for many years, you then apply for your citizenship and you're given a naturalization certificate. That's one way, that's called naturalization. Derivation is when you're the parent of a non-USC or a person who has not been born in the United States, and you've naturalized into a citizen before the child turned 18 and other conditions are met. So some of those conditions include who the person was living with the custody of who the child was under and their own status, right? So if that individual meets that criteria, he might actually be eligible for U.S. citizenship through derivation. There's another way to become a U.S. citizen, and that's through acquisition, and that's for individuals that are born abroad to U.S. citizen parents in some cases. The applicable rules depend on the citizenship, gender, and length of residence in the U.S. of the parents. So the immigration attorneys will be screening for this. If we see something like that, then we definitely don't want to go forward with DACA under these circumstances because they have something much better than that, and we will do and make the appropriate referrals. You should really not see any of these cases. So again, it's important to examine an applicant's parents' ability to naturalize because sometimes it's not obvious that the person has this means if you just look at them. Helpful links. These are some really good websites for you to keep in mind: NYC, The Door, Children's Aid, and of course the Legal Aid Society. These are the list of upcoming clinics. If you haven't already done so, please be sure to rank at least 2 clinics in your order of preference with your registration materials. We gave you a registration sheet. Please make sure that you do so that we can book you for the appropriate clinics. Also, thanks to the firm of Fragman, Del Rey, Bernstein, and Lowy, attorneys who have participated in this training will be eligible for 2 credits. And if you have attended the actual pro bono clinics, we are going to be offering 1 credit per 300 hours that you do. So in addition to the 2 credits, you will be able to get 1 credit. So if you participate in all 4, you might get 1 credit and like change. We're not sure what the change is going to be if you're interested, but let us know. In order for you to get that credit though, you have to you have to go into our website, that website, and you have to sign an affirmation. So basically you have to say, I went to this clinic for this amount of time. all right? And then that's how you actually get the credit. And now we will take questions. And of course, we want to thank those people who have been incredibly helpful. The Legal Aid Society, of course, Maria Navarro, who's been our expert. The Brooklyn Defender Services, the DOOR, Cyrus D. Meta and Associates, law offices of Linda Kanapaski, the Puerto Rican Bar Association, the Dominican Bar Association, the Nigerian Lawyers Association, Brooklyn Center for Quality Life, New York Immigration Coalition, and the New York Community Trust, all partners in this really exciting initiative that we're undertaking. And we thank you, of course, for coming to us this evening and taking part in this training. With the questions, because we are recording, it's important that you get the mic before you start talking, and Carlin is going to be walking around, so if you have a question, raise your hand.
Testing.
I've been seeing students at community colleges, and the myth going around is that the deferred action prevents you from obtaining citizenship, and I just want to be able to say to them definitively that that's not true, that it doesn't offer you citizenship, but it's not going to be a bar to you naturalizing in any other way. Is that correct?
I think we have to repeat the question for the video, is that right, or no?
Oh, okay.
Okay, so the question was just whether applying for DACA can prevent you from becoming a citizen in the future, and the answer is no.
Okay, great. And then I have one more, if that's okay.
Okay.
For people who are beefing up their application and saying, I've been working for a certain period of time and this is where I've been working, I've heard concerns that, well, I don't want to reveal that information because, will my employers find out? Will somebody else find out that I'm applying for this? Will they be implicated? And is that a possibility that we should be advising people about, or is that not something that this program will entertain?
The question was whether if you list all your employers, that's going to put the employer at risk, or that the employer may find out.
Correct.
In the past, we have not seen that employers have found out that they've done this. Sometimes people will ask employers for letters confirming that they've been working there. Many of the people you're going to see have been working off the books, and so employers are going to be hesitant and may not be willing to do it. Some people have obtained ITINs, individual taxpayer identification numbers, and that should be sufficient proof. So if some people are concerned and have that, I don't think they need a separate employer letter. And we have not seen employers contacted. I don't know if Barbara has anything to add.
We haven't, but we would also recommend that you avoid that if possible. If there's alternative pieces of evidence that you can provide that show that you've been here continuously for 5 years, I would recommend that you go with that. Because there's really no particular place in the forms that require you to put down an employment history.
Right.
So if we don't need to open that door, let's not.
Yeah.
There will be some cases where that's the only piece of evidence that they've been here, right? So under those circumstances, we might address that question differently.
Thank you.
So she's going to take the question, but I'm going to walk the mic around, so no need to come to the mic. It'll come to you.
I believe that you said that if they're accepted, they have a 2-year period that this will be valid. In the event that for some reason, whether a new administration or something like that, should terminate, does that 2-year guarantee still qualify? That's my first question. And second, after the 2 years, these people have given information that might make them more vulnerable to deportation. Has that been considered?
So I guess I'll take the first. Well, with respect to your first question,
The
Which-
question is, does the 2-year guarantee continue? Is that a guarantee even if this law should be terminated by a new administration?
so we anticipate that if there is a termination by a new administration and someone already has the 2-year work permit, we imagine that that's going to be allowed to lapse, such that they're not just
Okay.
going to be revoking the permit. With respect to your second question, we have guidance in writing. The FAQs are in your materials. They begin at page 41, and those are the most recent guidance that we've received from USCIS. We've been told that USCIS will not be sharing information obtained for the purposes of DACA with ICE for removal enforcement.
That's a guarantee?
Unless, right, they always give you an unless it's in order to identify criminal investigations or fraud. So to the extent that we have something in writing from from USCIS indicating to us they're not going to do that, we have it. Is that going to be the same as law? No, but it's the only guidance that we have.
And we also have the past where they have made these same promises through Amnesty, through TPS, and they haven't shared that information unless there's some other reason, an arrest, some threat of terrorism. But if you're asking us to guarantee it, I don't think we can tell you that it's guaranteed, no. And that is the same information. It's a common question that applicants have, and that's the same answer that we, I think, have to give them.
And the other suggestion I wanted to give was in your discussion about extraordinary circumstances that would be investigated, whereby the applicant might be permitted to go, to be accepted. Wouldn't it be wise to see how the courts, how the immigration will go, to see how strict they are, because once they put the application, you have indicated that they become vulnerable for deportation if they are not accepted. And I wonder if it's not wise to wait until you see the track record of these people who are determining whether they are accepted or not.
Yes, I think that's a good point, and we have talked to the few people that we are anticipating helping where they do have this issue, and it's up to them. Some people do not want to wait, and others, are ready to wait and see how these things happen. So that is part of what we have been advising people, that that's a possibility, is waiting and see what's happening with other cases, since there is no deadline. So that's also a good point.
And the third thing is an ACD considered bar, an ACD in criminal court?
It's not considered a bar, but again, I think depending on the charges, it could be considered on the discretion.
Hi, and just with regard to a high school diploma, has there been consideration for special ed students who aren't able to earn a diploma if I think they call it a certificate of completion of their program or their IEP? Has that been considered, that would be sufficient?
It's not a question that I've thought about much. I'd have to get back to you definitively because it's not something that we've thought about.
In the eligibility criteria section, one of the criteria is that the applicant must have lived continuously in the U.S. for 5 years. And brief, innocent, casual departure is okay if, and one of the sub-criteria is that the absence is a short absence. Can you give us some color on what constitutes a short absence?
Well, we haven't received much guidance with respect to that concept, but I think that if your short absence is, I went abroad because my grandmother was sick for 2 weeks and came back, that seems to me like a reasonable, short, and excusable absence. If you're going abroad every 4 months, to hang out, be on vacation, I think that loses the short absence quality of it. But we'd have to look at that on a case by case.
And there is case law because that term comes up in other contexts, and so it is a case-by-case analysis, but I would say like 60 to 90 days is, and if you're going on vacation, a short trip, you went to do something, and it's clear it was just a short trip and you intended to come back, I think it's not a problem.
I think it's 2 years from the date of approval. So when your EAD will have an expiration date on it, so you should be applying for renewal within a few months of that deadline.
For the evidence of age requirement, under this, have an affidavit by parents, not done immigration law work before. Is that providing that affidavit if the parents are also here illegally? Is that something that they should be concerned about?
Well, I mean, that is a last case resort. Sometimes some kids are born in places where births are not registered. And so when you have that situation, you don't have firsthand accounts of the birth. We would recommend in those circumstances for the parents to try to go back to the schools, because sometimes if they aren't registered at a hospital, oftentimes what will happen is when they were enrolled in that school system, the school will have something on record that says the parents came on this date and said that the child was born on X date. That would be helpful secondary evidence to help support an affidavit of parents. But again, that's not the best form of evidence.
This question is on clarification on the age requirement. The number is 31 as of June 15th. If an individual qualifies on that date with all other qualifications being met, however, there is no expiration on this action, and then decides not to apply for 1 year, 2 year, 3 years, they're now no longer 31, but they have met the requirements of being age 31 on that date. They still qualify, correct?
Yes, if on June 15th that individual was not over 31, he is DACA eligible, and we don't have a deadline yet.
Right, so then at 34, 35, 36, with no, if the action is still in effect, they still qualify because they were 31 on June 15, 2012.
Right, provided that they submit all the required documentation and can establish that.
Thank you.
The question is, enters, I guess, the initial entries are one of the questions on the form. The initial entry is 1995. And then the work permit asked was the last entry. So what happens if the person travels between 1995 and 2005? Those trips have to be listed or not?
So the question is, what happens if they've traveled in and out of the country prior to 2007, which is when the continuous presence requirement is? USCIS has said that they're concerned about the travel between 2007 and 2012. Yes, because there's no place there for you to include it. And like I said, they're concerned about 2007 through 2012.
So this program does not waive unlawful presence or entry without inspection problems in future naturalization applications, correct?
That's correct. The only thing it does is it pauses it. So if you've accrued unlawful presence, so for instance, if you are an individual that is over the age of 18 and you've already accrued 2 years of unlawful presence, getting DACA does not cure your inadmissibility, right? Because you still have that unlawful presence should you travel and then come back.
Which is why we also have a travel advisory, because people will be able to apply for advance parole to travel, but there's no guarantee that they're going to let them back in if they have an unlawful presence issue. So we've given out an advisory. And it looks like Cyrus may want to say something, or no? Okay.
I assume that, thank you for doing this, by the way. I assume that many of the people who will be applying for DACA are currently under the radar. If in 4 months there's a change of administration, we address that issue, but if there's a change in administration, well, let me take a step back. There have been news reports of litigation commenced by various agents of ICE, I think it is, contesting DACA and the the actions that ICE or President Obama has taken in this regard as being unconstitutional. It's, I imagine, very hard to handicap how that litigation is going to come out, but if it is declared unconstitutional or violative of the law, or if another administration, if Romney wins the election and becomes president in January of 2013, and takes the position for his administration that it is in fact unconstitutional and against the law and changes it, these people will now be above the radar and subject to deportation. Is that correct?
They could theoretically be subject to deportation. It depends on what USCIS does with the information they've acquired. As I said earlier, the FAQs indicate that they will not be sharing that information for purposes of enforcement, but it is a risk. And I should say that all the individuals that you will meet at these clinics will have been through a very detailed informational session where that risk has been explained and disclosed to them. They have gone through something very similar to this, except it wasn't like 2 hours long.
And one more thing, now that you mentioned the clinics, maybe I missed it, though I thought I was here at the beginning. Can you describe the clinics and how applicants get to the clinics and what they have to do to register for the clinics and that kind of thing? Thank you very much.
Sure. So for the clinics, what we've done is some community outreach, and we've also worked with longstanding partners. So the first clinic we're going to do is with BMCC, and they're one of our long outstanding partners. That's going to be geared toward CUNY students, and those individuals will have gone, like I said, through an informational session. They will already have their intake and prior address history worksheet completed by the time you see them September 10th. We've also planned one clinic with NYIC, the Immigration Coalition, and those individuals will also have a copy of our intake as well as our prior history, and they will be RSVPing directly to NYIC. For the final 2 clinics, they will be RSVPing to the Department of State. They're handling our RSVPs, and so they will also be given our intake and prior address history.
And just as a point of information, so far the people that we've seen have been really highly educated on these questions, and they're having the same questions you are. They come in, they've read the FAQs, they've highlighted them. They're really well prepared and want to know the same thing you do and understand that they are taking a potential risk. So this group of people seems to be pretty highly educated and knows where to go to look for information, and a lot of them have been sort of organizing beforehand on the DREAM Act, and so already are very pretty savvy on immigration issues.
With regards to the travel requirement, people will get advanced parole to travel, and you did mention that there's a risk that they could trigger the 3-year or 10-year bar if they've already accrued unlawful presence. But there was a remarkable case from the BIA, matter of Arabelli and Yarabelli, which has said that a departure under advanced parole is not considered a departure for purposes of triggering the 3-year or 10-year bar. And although it's not clear here, but we need to advocate that a departure under advanced parole for a DACA applicant should also not trigger the 10-year bar. So
And
that's something that we have to watch out for,
Right.
and it's worth advocating for down the road.
And it was asked at one of the advocate meetings, and in the New York office was pretty vague and said, we're applying it in specific cases that fall right under that case, and would really not answer whether they were going to apply that in DACA cases, which is why we're being cautious about it.
I've seen a number of cases resolved in criminal court with ACD and community service. Does that community service change that ACD from a non-conviction to something that should be listed, of course, given what the original arrest was for?
If the community service was completed and it was dismissed, it should still be okay as far as a conviction. But again, the underlying actions could be considered on discretion, and they could be asked to bring in criminal records. So again, we would probably want to look at it and ask the underlying circumstances of the arrest.
What if somebody has been in the military but was not discharged as of June 15th? They're either still serving, and what if they're serving in the military but abroad on June 15th, but then come back?
Well, the eligibility criteria has to be met as of June 15th. So unfortunately for that individual, if he's still active and hasn't been discharged, he won't be eligible under DACA.
Are these materials, application forms, are they going to be translated in other languages? For example, Spanish?
Unfortunately, we haven't gotten that information from USCIS. In the past, they haven't. What we will do is provide translators on site to assist the volunteer attorneys.
Many times, young people use a variety of names for various reasons. Will using aliases or having used aliases be a bar, or how is that going to be handled?
The application actually asks for other names used, and so they should be listed on there. You want to be sure that you don't have problems in the future. I think that would require, then want you to ask, well, why were you using these names, to make sure it doesn't raise other issues that could be problematic. But the application does ask for it, and so they should be listed.
Hi. Should you explain at the beginning of the intake?
So one of the things that the materials includes is a confidentiality agreement that the attorneys have to sign, as well as a limited scope agreement that both the volunteer attorneys and the individual needs to complete. Yes, confidentiality is very important, and that's something that the screeners will discuss with them. But, redundancies are wonderful. So if you feel the need to, say, hi, my name is Attorney X, and I just want you to be aware that everything you say to me will not leave, the parameters of this room, that's perfectly okay too.
Hi, I'm Lenny Benson. I teach in New York Law School, and I'm City Bar Immigration Subcommittee Chair. So in all those capacities, I'm helping with this. So I'm going to ask an advanced question, if it's all right. On military service, I was conferring with Margaret Stock, who has written a book for AILA on military service, and she and I are of the view it's a red flag, and anyone who has military service needs a consultation by an immigration attorney, because either they have a direct path to citizenship, or they probably committed fraud to get enrolled in the military, and they could have possible criminal sanctions. So I didn't know if you're taking a different position, or if you're, it just seemed to me that I think we should be careful about the military service cases.
Yeah,
so
it's a good point for you to raise, and definitely something that our screeners will be sort of asked to review. It's totally accurate. If you're in the military, there are other ways for you to obtain permanency. If we have individuals that are in the military and don't meet the definition to go forward, we're definitely going to try to refer them out.
Any other questions?
Okay, well, thank you, everyone.